Hi, everyone. Thanks so much for joining me today. My name is Krista Wetmore, and you're watching the Money Mindset Show. So today I thought I would talk about a topic that Rivers had sent me a little note, and he said this is pretty cool. The difference between common law and marriage. And over the years, it's one of those topics that a lot of my friends and some clients assume that it's the same, but there are some similarities, but there are some significant differences when it comes to being common law and being married. So it's one of the things that I always ask my clients if I'm doing a financial plan. It's one of the first questions I ask. Are you married or are you living common law? And you'd be surprised over the years how many times the answer I've received is, well, it's one and the same, which I respond to, no, it's not. So anyway, there is a clear distinction. So I'm going to walk you through some examples so you'll have an idea of what I'm talking about. So let's just look at what is the definition of common law. And for that definition, I looked at the Federal Income Tax Act, which is really fun to read. I highly recommend it for anybody that's looking for some beautiful summer reading to do. I'm just joking, obviously, but anyway, it's federally, and this is where the confusion comes in place. So let me just recap what I read. So if you cohabitate in a conjugal relationship more than 12 months or less than 12 months if you have a child, whether a child is adopted or a natural child, you can be considered, again, through the Federal Income Tax Act, to be living common law. So that's where the distinction and, again, the confusion comes in place, because when you're doing your income tax return and you click on that little box that you're living common law, what that means is, from a taxation standpoint, your tax is the same if you're common law or if you're married. So again, that's where the confusion kind of comes in. So tax the same, meaning there are some advantages and some disadvantages to being taxed if you're in a common law relationship as you would be married. Some of the advantages would be if you have a pension. So some of the pensions you can divide. So the lower income earner you can divide some of the pension income to them. So it helps reduce your taxation. Some of the disadvantages to clicking or being married or living common law would be you may lose some tax credits. And by that, I would mean you have to pool your income as a household for the two partners. So you may receive less or no GST, child tax credit, or even a guaranteed income supplement through the old age security. So just a couple things to keep in mind with that. Let's just change gears here and talk about family laws. So again, I'm not a lawyer, but I just want to give you some advice and some high-level information about the significant differences, and you'll be able to see as I walk through some of these examples what those significant differences are. So for family law, this is provincially legislated, not federal. So keep in mind, income tax is the federal, family law is provincial, so there is a difference on this. Don't assume it's the same, because it's not. So family property is one of the biggest things, I guess, that I get into discussions with clients about. So for a division of a property, so in the event that you have a marital breakdown, so if a married couple ends up divorcing, per se, the division of the property is for married spouses only. Does not consider if you're living common law. And that is something that's often overlooked. Of course, with everything in law or taxation, there's always exceptions to the rule. And there is an exception with this as well. You can sign it's called a cohabitation agreement. So what that basically is a contract. So you'd be putting something down in writing to say how any property would be divided if you are living common law and that relationship dissolves. So again, I'd recommend, if you're living common law, speak with a lawyer if you do have significant assets, and just to protect yourself, either if you do have the property or if you don't. One of the things, I'm not going to touch on the pensions. Pensions are a little tricky, depends on the type of pensions. Every province is a little bit different when it comes to pensions and how that works if you are in a common law relationship, and as well as whether or not you're entitled to CPP. So any pension type of questions, I would speak with a family lawyer about, and see if you can see if they have some answers for you as far as what jurisdiction you're living in. Through this term up here, and it's called unjust enrichment. And what basically that means is, so for example, if I'm living common law and I am paying towards the monthly mortgage payment on that house, I may have a claim against that property if that relationship dissolves. However, when I say that unjust enrichment, what that means is you're basically filing a lawsuit. So with lawsuits, they are unpredictable, they are expensive, and they can take quite a bit of time. So if you do have a property, again, I would recommend speaking with a lawyer and having something written out prior to. Don't assume that you would be entitled to a part of that property. Joint property is always something that's interesting. And, you know, if you are living in common law and you want to add your partner to the title of the property, then they are a shareholder basically in that property. So in some cases, when we're doing financial planning, we do recommend to avoid probate fees in some cases. Just makes it easier if you're settling the estate and flowing through assets from one hand to another. It does make it easier if it's joint. However, keep in mind, if you are adding somebody onto a title, you may be foregoing that property or protecting it if you don't need to share it. So again, just be something to keep in mind on that. Spousal support, again, that's a tricky one. Every province is different, every situation is different. Spousal support, the only reason I put the title up here is just to remind me to talk about it. And I just want to point out, if you are living common law, and so for example, if I'm living common law with my partner John, and John has a dependent child living with him, I could be in a position where I may have to provide child support going forward. But again, child support, spousal support's really gray area. Again, every province is different, jurisdictions are different, laws are different, situations are different, amounts are different. And again, I would definitely speak with a family lawyer to seek more information on that. Just going to touch on the estate planning for a minute. And this is a really important point I want to make, that if you are living in New Brunswick and if you are common law and you do not have a will, you do not have any rights to inherit property. So again, let me repeat that. If you're living in New Brunswick and you're a common law with no will, your partner has no right to inherit the property. That's just generally speaking. So that is huge. This is, again, a very significant difference of common law versus marriage. Now, having said this, there's always exceptions. So you can fill out an application for dependent relief. You may have a right to that property, but again, it depends on the situation. It would have to go to the court. You have to speak with lawyers about it. So if you don't have anything written down as far as a will or any other type of agreements, you're opening yourself up to a lot of uncertainty. This is something that a lot of people, my next point here, a lot of people don't know about it, and it's a previous will. So for example, if I am single and I have a will drawn up and I get married and I marry John, as soon as I get married, that will that I had drawn up when I was single is void. So it's automatically canceled. So my recommendation is when people do get married, if they did have a will, you need to have your will updated because you don't have a will anymore. The other thing I want to point out with this as well, and a lot of people don't know about, if I have a will, so for example, and if I enter into a common law relationship with John, what happens to that is in that common law relationship, the will is not void, so that will stays intact. So if something happened and I was to pass away, it could expose me if I had a previous spouse. That will would still stay in place, and my estate could go to a former spouse. So again, that's a huge difference between common law and marriage is when you're looking at the wills. So again, speak with somebody like myself or your lawyer to get some more information on that. So a few things that I recommend here, I'm just going to go through them quickly. I would recommend to clients, if you are entering a common law relationship, just make a formal note of the date that you're moving in. If you've rented a U-Haul or if you have a moving truck or anything that would sort of determine that. Date, again, just from a taxation standpoint, but also from a legal standpoint, you want to have that firm date written down because it does make a difference. If you are moving to another province and if you are living common law, definitely seek some advice as far as what the common law laws are in that other province, again, because you don't want to leave yourself exposed to different laws, and don't assume that they're the same in the province that you left because they may or may not be. One thing that I come across as well quite a bit is somebody has property in another province. So for example, if I am living common law and I have my house in New Brunswick, let's say I have a cottage in Nova Scotia, I pass away. So for example, if I don't have a will and I pass away, the personal property that I have in New Brunswick is going to be divided by New Brunswick laws. However, the property in Nova Scotia, the cottage I have in Nova Scotia, because it's real property, that real property is going to be divided according to Nova Scotia laws. And again, because the laws vary from province to province for common law, you could end up in a situation where it's two different types of governing laws for both of those properties. So again, just something to bring yourself, to make you aware of that. And again, I would definitely recommend speaking with a lawyer. And I guess in closing, I think that is pretty much most of my time. I'm just going to see if there's any questions. Doesn't look like I have any questions today. However, again, I hope that gives you a clear understanding what the differences are between a common law relationship and a marriage. And again, don't be fooled just because you're paying the same income tax rules apply are the same for common law and marriage. Don't be confused, because it does make a difference when it comes to estate planning as well as financial planning. But estate planning and family laws can vary significantly. So again, if you have any questions, please reach out to me. Likewise, if you have any suggestions for future topics, please let me know. And wish everyone a great day, and we'll see you again next week. Bye-bye.